It's just turned 2 o'clock, so we're one of the elements of this research centre is that we're going to be very punctual and always aim to start on time and always aim to finish on time. So we'll go ahead and get started now. So thank you everybody for attending today's inaugural session of the Performance with Purpose Research Centre. We've got a great schedule for our first event. We're going to be starting off with the director of the research centre, who's going to give us a warm welcome to everyone and give us a bit of initial information on the research centre and its purpose and its focus. And our first presenter of a series of presentations and talks that we're planning is Professor Henry Blair, who's going to be talking to us about smart contracts. And after Henry's presentation, I'm going to be taking a little slot myself and talking to you about the schedule of events that we've got planned for the rest of the academic year, and also just giving you a little bit of a preview of some of the things that we're holding back in our back pocket for events for next year, but which we haven't actually got a fixed date for yet. And then finally, we're going to be opening up the floor, the digital floor, of course, to attendees who want to ask any questions that they have about the research centre. Myself and Nigel will be doing our best to answer those. So thanks everyone again for coming, and I'm going to pass you over now to Nigel, who's going to give us a welcome. Over to you, Nigel.
Thank you, Steve. Good afternoon and welcome to this inaugural first session. I saw in my diary yesterday that Henry and I have been planning to meet face to face since October, and we have not actually managed it due to a lot of COVID. And certainly COVID has had a number of impacts on us, and I don't think even before COVID, we wouldn't have dreamed of launching a research centre and carrying it on with a lot of virtual content like this. But we believe that this is the best format for us right now. And part of that is, in trying to get this research centre going, I've always said that it needs to be part of people's day job, not another job, not another task. And I think it's incumbent on us to try and put on events which are relatable for you, that are helpful for you. And it must have been virtually because we've never met, but Henry and I were chatting, and I was talking about intermediaries, and somehow smart contracts came up. And I thought, what a connection that we can make between the work that some of us are doing now on intermediaries, and even the coming work on we're going to get into on smaller businesses. And I was delighted to see this kind of connection. And so what I think what it came about because I had seen a lot of my students presenting on blockchain, and every presentation on blockchain says blockchain is going to come along and wipe out all intermediaries. And I saw another paper, one of many, on smart contracts, which tells us that smart contracts are going to come along and they're going to wipe out intermediaries in the form of lawyers. So one of the challenges for Henry today is to explain to us not just what smart contracts are, why they are a threat to lawyers, and probably why lawyers will continue to exist, I think, after smart contracts have been introduced. I guess the last thing I wanted to say is that we're very much testing what's going to work best for us, and we're testing this slot. Now, to Steve and I, this seems a very good slot, sort of 2 till 4 maximum on a Friday afternoon, and that's something we want to find out about as well. But I'm very pleased to hand over now to our new Professor of Commercial Law, Henry Blair, and I think he's going to talk for 25 minutes, half an hour, and and hopefully that will raise a lot of interesting issues for all of us that we can relate to the research that we're doing or starting to do now. Okay, over to you, Henry.
Thank you, Nigel, and it's thrilling to be here. I appreciate being invited to this center for the first presentation. And as Nigel said, he and I have attempted to meet in the real world for a very long time, but I have had the opportunity to work with Nigel on a variety of different committees, and I've gotten to know him, and I could not be more excited about his leadership for this center and seeing the presentations that are going to come after this one. And again, I'm super thrilled and honored to be here to kick things off. I'm going to attempt to share some slides now to talk about smart contracting. I don't know, is everyone able to see those slides? Anyone? Oh, there we go. Smart contract slides. I see them loading now. There we go. Ah, ta-da. Just took a minute. I apologize. I'm not used to this format. So my goal in these 20-25 minutes or so is to introduce the idea of smart contracting for those of you who might not have a firm idea in your mind about what we mean when we say smart contracts, and then to think a little bit about the challenges, as Nigel said, that this raises for traditional lawyers and the process of lawyering. As he said, many presentations and many people who are talking about smart contracting talk about it as though it is somehow going to eliminate the need for commercial lawyers. I'll just share a very brief personal story for a moment. My partner and I, when I first went on a date with them, they asked me if I did interesting criminal law or if I did something boring like commercial law. And my response was that commercial law can be interesting too. And so I've always had this vision of commercial lawyers as doing really important and interesting work. But smart contracting does raise some questions about what that work will look like into the future. I will say that one of the challenges in talking about smart contracts is that I find that sometimes law students in particular, but also just lawyers and sometimes law professors and others are a little bit phobic when it comes to maths. And part of the challenge of thinking about smart contracting and what it will mean for the practice of law is trying to understand smart contracts somewhat abstracted from the way that the actual processes that are making up smart contracting. And it's possible to do, but the actual maths can get kind of daunting for some people. So my goal here is not to do a whole lot of mathematical talk about the processes that are actually underpinning the technology of smart contracts, but instead to talk at a high level about how smart contracting is working. There's been lots of attention in recent years about this idea of AI more generally, and smart contracts are not themselves AI, but they can often be paired with AI, and in some ways the challenges to lawyers and lawyering revolves not only around the use of smart contracts, but the use of artificial intelligence to augment or to work with blockchain technologies to eliminate the need for lawyers. And so we can have dispute resolution processes that are AI driven or other things. I'll talk more about that in a minute. But the idea of both blockchain and AI as replacing lawyers, and that we would have a robot soon doing the job of a lawyer, has been in the news for really since 2015, and in some instances even earlier than that, right at the cusp of AI becoming a significant factor in the world, when we started to imagine self-driving cars and when we started to imagine Google being able to predict the sorts of things that Google can predict, the sort of predictive algorithms that allow us when we go shopping on Amazon and Amazon to know, or seemingly out of the blue, what it is that we're thinking. All of those sorts of things have led people to think that maybe lawyers are going to be next in the line of professions that can be replaced. Of course, not everything is probably so dire, and there's been a lot of pushback about that. The National Law Review, which is a fairly important publication in law, certainly in North America, but it's also a publication that gets attention worldwide, published something in 2017 talking about artificial intelligence as a game changer, and basically uh, they did some balanced analysis of this, and I think at the end of the day, what one can worry about is what's sometimes called the Gartner hype cycle. That when we get new technologies, we have this inflated expectation about what those technologies may ultimately be capable of doing. And then there's a period of time where we realize that those technologies aren't changing that much. And then slowly we begin to, the disappointment we have, the disillusionment may go too far, and we slowly begin to find a plateau of understanding about exactly what technologies can do for us. And I think that we're likely to see something like that with smart contracting and the use of AI when it comes to the role of lawyers. I think unequivocally, smart contracting will change the way that lawyering has to be done, and particularly commercial lawyering, but it's not going to replace lawyers entirely, I don't think. To Nigel's point, the thing that he and I began to talk about, this notion that smart contracts might do away with intermediaries. That, of course, means the intermediaries are the law and lawyers. I'll say more about that in a second again. But again, I don't think that we're going to completely remove all of that. Just so I'm situating this, because for me, it's not simply about blockchains and smart contracts. I just want to mention this idea of AI and talk very briefly about AI, because again, I think the pairing of those two things presents the most existential challenges to law and the process of lawyering. So when we think about the basics of AI, we can think about a rough and ready definition here, where we're using computers or computation to solve problems or make automated decisions for tasks that humans routinely do, and that we think of as requiring some sort of intelligence. There are lots of things using this very basic definition of AI that qualify as artificial intelligence, including many algorithmic processes that are not really predictive, that are not really adaptive necessarily, but they do use computation to make decisions that humans are routinely doing, that we usually think of as requiring some level of intellect. So the way that I've sort of conceptualized this in my own brain is to distinguish between sort of stronger senses of AI and weaker senses of AI. On the weak side of things, anything that's amounting to computers solving problems by spotting patterns in data can be theoretically talked about as AI, because we have conventionally seen humans as spotting patterns in data. Why does this matter? Well, one very simple use of AI in law has been to do document coding, document review. So lawyers are often in dispute resolution processes having to look at masses of documents that are relevant to the dispute. It used to be once upon a time that lawyers would have to put their eyeballs on all of those documents, but we now use computer coding, predictive coding, to scan the documents and have a computer go through and find patterns in the documents that humans may or may not have spotted in the first place. And using that predictive coding, we are generating or identifying out of a set of maybe 1,000,000 possibly relevant documents, a smaller set of 10,000 that then humans actually review. So humans are no longer putting their eyeballs on 1,000,000 documents in a case. That's weak AI. There's nothing, the computer's not doing any sort of adaptive thinking, but it is looking for patterns in the data and saving labor, human labor. And that all by itself has changed the practice of law quite dramatically. So I bring that example up as an example of the ways in which technologies aren't eliminating the intermediary, aren't doing away with lawyers, but they are shifting the way that lawyers have to think and work. And I think, again, that's analogous to what we'll see with smart contracting. On the smart side of AI, we have things where computers are solving problems at a higher level, commensurate with or surpassing what humans are doing. And this can often involve, or at least look like it's involving, abstract reasoning or inductive thinking. So there are fewer examples of this in practice, at least right now, but smart driving, self-driving cars would be one of those examples, right? Where there has to be adaptive changes to the environment are taking place, and the car has to be adaptive to adjust to those changes. So at the end of the day, we can kind of think about AI as this sort of constellation of different kinds of understanding, computer understanding. So we've got basic algorithms at sort of the lowest level, and algorithms have been around for, well, hundreds of years, really. I mean, anytime there's a basic process and procedure, we can think of those as being algorithmic. I will just note that, again, even more modern computer-driven algorithms have changed the way that lawyers have to function and operate. It used to be the case that law was a much more protected and insulated profession. These days, if you want to write a will, or you want to even write a contract or do other things, you can go find online platforms that will ask you a series of questions and will generate a document for you based on your answers to those questions. The computer is not doing any adaptive thinking, and those aren't smart contracts, as we'll talk about, but they are challenges to the traditional way that we understood the role of lawyers. Then we've got deep learning, which is a deeper kind of analysis of data, all the way to machine learning, where the machine is taking a very basic set of algorithms and then extrapolating from those algorithms in order to do deeper analysis of data that it itself has sort of generated. So it's not exactly creating its own algorithms, but it's sort of creating its own algorithms. And then all the way to truly adaptive artificial intelligence. Again, we don't have a whole lot of that in the modern world yet. So all of this stuff is creating these tensions between traditional notions of how we understood AI and more extreme versions of AI, create some tensions in how we understand and think about challenges to law. And so in many ways, this talk for me is stems out of, again, what Nigel and I were talking about, where he asked me pretty point blank, what did I think about the possibility of smart contracts replacing lawyers, or replacing intermediaries is the word he used. And I want to distinguish between those a little bit, though I think that we can simplify and say law, and then the role of lawyers interests me as someone in the law school. So let me just skip forward to a couple of examples of AI's uses, and then we'll turn to smart contracts specifically. So again, we see AI in many of these sorts of algorithmic and consumer-facing technologies, where consumers can go online and potentially write their own wills, or they can create small little contracts for themselves, or they can even get advice about problems that they're having in certain circumstances, like tax circumstances or other sorts of circumstances. We can see this in the ways that even generating a basic flow chart can be a kind of algorithm that, of course, can be used in law. And then more and more we see this with, again, sort of client-facing services that some law firms are adopting. So a very burgeoning industry right now is surrounds client intake processes, where we're using algorithmic approaches to asking questions. So we're winding up asking our intake of our clients similar questions in a similar order, and that we can begin to spot patterns in the data from this more rigid and structured intake process. And also that intake process can become more and more automated, saving lawyers time and clients money, depending on the nature of the dispute. So all of those are examples of the ways that we're currently using are using AI. So let's turn and think about how we're using smart contracts and what we do or mean when we say smart contracts. So when you think about smart contracts, there are a number of things that we can do, which is to ask, why smart contracts? What is a smart contract? Let's actually start with the what is a smart contract. So at its most sort of basic and simple, a smart contract is a computer code that's running on blockchain, and it enables secure value exchange. Smart contracts, in theory, are removing the need for any sort of intermediary. So anyone like a lawyer, at least, who needs to be involved, any court process to enforce the contract, there's no need to worry about enforcement, because the blockchain will do the enforcement itself. And the basic idea here is that the blockchain is a decentralized and immutable public ledger out there in the world. So part of the security, in theory, of the blockchain is that it's publicly available and accountable. And the computer code ensures that I think of it like a playground logic. So sometimes when I teach contracts, I think about the self-help remedies that parties have under contract law. It's a bit of a playground logic. I hand over the money at the same time that someone else is handing me, say, the keys to a new car. I can hold my money and I can keep my money myself. The self-help remedy is that if they don't give me the keys, I don't give them the money. And similarly, their self-help remedy is they keep the keys if I don't hand them the money. So the simultaneous nature of the exchange, like children on a playground, is what's protecting the expectations of the parties. And in many instances, we don't need law at all in those sorts of simultaneous exchanges because the parties can be made not whole necessarily, but they can protect themselves well enough in most instances or in many instances that even if the deal doesn't go through and their expectations are therefore disappointed, they haven't put themselves in any harm. They haven't given up anything, so they haven't relied to their detriment in any way. So we'll move forward. Of course, contracts are usually thinking about prospective expectations, and that may still be disappointed, and that might or might not be worth bringing a lawsuit. But that playground logic is fundamentally holding together many deals without any need for law. That's what smart contracts do. So the distributed ledger allows parties to create through the computer code the terms and conditions of the exchange, which the computer verifies for each party that the computer effectively becomes a kind of intermediary, the blockchain does, but it's an intermediary that doesn't have any discretion or any decision-making authority. It's simply looking to see if a series of conditions have been satisfied by each of the parties, and if so, it releases the consideration to each of the parties, and away we go. So the idea of smart contracts is that we don't have any third parties, we don't have any confusion about what the terms are or anything. And it sort of works in 5 basic steps. There's the offer. The transaction process starts much like it would with any other contract. The first party writes out the terms of the agreement, but it does so in a sort of if-then statement. That if-then statement just sets up the conditions on which the offer will be accepted. So it's a kind of, in a sense, it's a kind of unilateral contract, although it could involve bilateral promises, but it's this setup, the offer creates this setup of if-then statements that are placed onto the blockchain. There can be negotiation, and the terms then are visible to any party on the blockchain, so the two parties can now negotiate about these contract terms if they want to. And that again resembles a traditional contract. And so I should point out that in especially this second phase, this is where we can say that commercial law doesn't necessarily change a whole lot, in the sense that lawyers, when they're doing their work as commercial lawyers, are helping their clients assess a deal and think about the risks and the benefits of the deal at a higher level. And as partners in the negotiation process, lawyers would continue to have a similar role to what they would have today. Once the terms, this if-then statement and the terms of the if-then statement are set and everyone agrees to it, then the two parties agree on these terms, and triggering events such as the due date, the expiration date, the strike price, or any other conditions of the contract all become immutable and they're locked in. And so that's why we can say that this is a contract. Of course, we define contract as a promise or a set of promises that the law will enforce. Only now we can remove law because, well, do we really need law at all? We just have the blockchain, which again is relying on this self-help remedy. If someone breaches, then the other party hasn't released their consideration. And so at the very least, they remain in the same position they were in before. Now, again, that does not validate future expectation. And again, I'll come back to that because I think that's really important, especially in some large commercial contracts. But the parties at least aren't hurt or aren't in any worse condition than they were in before they entered into the contract. Then, of course, the fourth step is satisfying those conditions. After each party has approved the contract, then the smart contracts will verify whether these conditions have been satisfied. This is the series of if-then statements. And then the triggering event, whatever it is, the final triggering event, usually the satisfaction of all of the if-then statements, although they can be more complicated. So it may be that there can be chains of the if-then statements, but whatever the final triggering event is, so long as it's satisfied, then there's a transfer of the assets, or the transfer of the values, or what we would call in contract law the transfer of the consideration. And so this concept is exciting because it allows for parties to have a lot more autonomy in the process and potentially save money. So just to put a fine point on it, smart contracting is different than traditional contracting, primarily because you can see on this slide, I've got the third party down here with a nice little courtroom image. In a smart contract, we can do away with that courtroom process. Now, by courtroom, I don't just mean, of course, courts, I mean the entire legal process. So we can do away with lawyers, we can do away with the need for law in general, and thus we can do away with the need for a dispute resolution process focused on law, at least in theory. And at least in theory, then, this winds up becoming a transaction that does not require that third party. Again, this is the intermediary that Nigel was initially talking about. It can happen in a much sort of faster way, and especially for routinized transactions, mass market transactions. So I would imagine that things like blockchain will become the norm for, say, renting a hotel room, for renting a car, for even buying a car. Standardized transactions that are pretty routine should become very easy and very fast using smart contracting and blockchain technologies. The remittance process is automatic. We don't have to have any sort of external person verifying or validating that that the conditions have been met. Again, the blockchain is doing that for us. It's transparent, and so in theory, this should reduce the ideas that it should reduce the incidences of fraud and other sorts of malicious behavior. And even it should eliminate the possibility of even accidental misstatements and other things, in theory at least, because we could have access to more eyeballs looking at it from the outside. It should be easy to archive and save this data and go back and look at it. So we should be able to have, to the extent, and again, I will say in a moment, that I think there's still a serious role for dispute resolution about these things, but we should have access to easy data. And it's as secure as the blockchain is. And many people, you can go find articles who talk about the fact that the blockchain is unassailably secure. I'm not sure that I have that much faith in the blockchain technology, but it is very secure. It is as secure as cryptography can make it. And I think that makes it quite secure as compared to other sorts of more antiquated transactional technologies. In terms of expense, it's definitely cheaper so long as we're not hiring intermediaries, because, well, you don't have to pay the costs of lawyers and other professionals. The parties can do this largely on their own, especially as they become more used to the if-then statements that are creating the blockchain, and those aren't particularly magical. Doesn't require any particular programming expertise. Certainly at the beginning, when parties are learning how to do this, it may require programmers and other things to be involved, but the actual technologies to write these things are very, very simple. And so in that sense, it should make the transactions cheaper. The platforms themselves, of course, charge money, and the blockchain itself may charge money, but again, distributed at least in mass market contexts, or in contexts where you're doing enough contracting, probably significantly cheaper. So there are significant advantages to smart contracts, but there are some problems. And so I will just end, or I see that I'm coming sort of close on my time, but I want to make sure I wrap up here with a few thoughts about the future and what I believe the future of lawyering looks like in a world of smart contracting. The problems, as I see it, with the notion that we're removing the intermediary revolve around a couple of misunderstandings, which is part of why I led with the thinking about artificial intelligence and the ideas that some of us have that artificial intelligence is maybe more advanced than it currently is. I think some of the concerns about smart contracts come from a misunderstanding of what smart contracts can do and be good at and what they can't do. Smart contracts, as I discussed in the 5 steps, involve the same basic steps for offering a contract. And what we're really doing there is translating the terms that we would normally have done in a traditional contract into a series of if-then statements. But it doesn't remove most of the concerns about if-then statements. It removes some, because again, the primary protection in the smart contract is this playground logic of unwinding the deal. But, and this is the second thing, that playground logic of unwinding the deal is providing a different remedial structure to smart contracts. Traditional contracting is interested in making sure that the parties get the value that they expect to get when the contract is fully performed. So the primary remedial stance for contracts is expectation damages, that we get the breaching party gets the damages that they would that put them in the position that they would have occupied had the contract been fully performed by both parties. Smart contracts base remedy is to basically unwind the contract and put the parties in the position that they occupied as though there was no contract. To the extent that remedy, that sort of remedial stance of putting the parties in the position that they occupied as though there was no contract, is less than expectation damages, which will happen quite frequently in the world. And that differential is worth the disappointed party bringing a lawsuit. Lawsuits are still going to happen. These smart contracts will not eliminate those lawsuits. Now, in many instances, the differential may not justify hiring lawyers and fighting about it. And in that sense, smart contracts are providing value to the world, because right now, under traditional contracting, where the differential between simply being put in the position that the parties were in before they contracted and where they would have been had the contract been fully performed, that differential doesn't justify the costs of a lawsuit. Well, right now, you still have to bring a lawsuit to get to that first position. So smart contracting will eliminate those lawsuits where there isn't value to be gained from expectation damages, where the expectation damages aren't big enough to be worthwhile, because you can still just get your money back, or effectively never have spent your money, to put it very simply. But it won't eliminate the larger gap, right, where it does make sense to bring a lawsuit for those expectation losses. And I think that will happen in many, many contracts in the world. There will still be a value to bringing a dispute. So in that sense, commercial lawyering doesn't change. And in that sense, the consequences of defining those if-then statements carefully and thoughtfully will really matter. Disputes will turn on not just whether the if-then statements were satisfied, but were those if-then statements fair? Were there problems with those if-then statements? All of those sorts of things will still be at issue. So the design process, commercial lawyering on the front end, while it will change somewhat so that it's reflecting the creation of these if-then statements, it's still a similar process, in the sense that lawyers still need to be thinking about the overhang of future disputes. In many ways, I think of the value that transactional lawyers are bringing. They're transactional designers, they're engineers. And what is the value of their engineering? The value of their engineering is to help design transactions to address the risk of future disputes, right? That there's a future fight. So lawyers are always thinking about that possible overhang of a future fight. Transactional lawyers are trying to minimize the risks of that future fight. In that sense, transactional designers will be as relevant to many smart contracts as they are today. The work will change, but the intermediary function will remain the same. And finally, I think that the process of dispute resolution is going to be important to smart contracts, because the satisfaction, whether those if-then statements have in fact been satisfied, many advocates of smart contracts, pardon me, sorry, suggest that the blockchain will be able to tell whether the conditions have been satisfied or not satisfied. That there'll just be that as though there is no process to that verification. And the idea is that in many instances, like paying money to rent a hotel room, it is true that the money can go into basically an escrow account. And so it's either there or it's not. So there's not much verification problem. But many complex contracts will have conditions that are not that simple, that are not that tangible. And there's still going to be a fight about whether those conditions were satisfied or not. Someone is still going to have to verify the satisfaction of the condition. And in that process of verifying, there can be disputes about whether that verification is accurate or not accurate. So even if you hire a third party appraiser or something to to determine whether someone has satisfied a condition, there can be fights about whether that third party appraiser, for instance, was bribed, or whether they were negligent in their own duties and those sorts of things. So that verification process, especially in complex contracts, will still require the help of lawyers. And thus, again, as transactional designers during that first phase, lawyers have to think long and hard about how those if-then statements work. So if I were predicting the future with the future ball, just to put a bow on all of this, I would say that smart contracting is very likely to become a primary driver in mass market contracts, and in many ways will provide a lot of value to the world because it will eliminate the lawsuits in that space where parties are going to feel mostly protected by not having to give up their own consideration if the deal falls through, if the other side fails to deliver. So they can be protected by this playground logic, and that's good enough for their remedial needs. In that sense, smart contracts will provide a lot of value because we can eliminate the need for lawyers and courtroom processes. But in any more complex transactions, smart contracts will still have value and will still be providing value to the world. They will change the way lawyering works, but it will not do away with the need for lawyers either on the front end as transactional designers, and especially it will not change the need for commercial litigators on the back end of the process. And with that, I'm going to pause and see if folks have questions. Thank you again, Nigel and Stephen, for inviting me for this presentation. It's been a lot of fun. I'm not sure how to turn these slides off.
Thank you, Henry. That was great. I've got a lot of questions. I must ask first of all, what is smart contracts going to do to the status of lawyers, if anything?
Yeah, I think that's a good question. In part because it will change the role lawyers have, or the ways that lawyers exercise that role, and so that may have an impact on the way that parties view lawyers. I actually think that what it probably will mean is that the status of lawyers will remain much the same, but there may be fewer transactional lawyers, certainly on the front end of smaller deals, and so that will make the lawyers that exist, I think, will probably occupy a similar status or potentially even a more prominent status in transactions, but it may create a distribution of lawyers that's different than we see right now.
Thank you. There are so many themes in what you've presented that resonate across what we're doing. Just before let anybody else ask a question, what impact, if any, will smart contracts have on smaller businesses, do you think?
I think that for many smaller businesses, because they're likely engaged in more routinized transactions, I think smart contracts will wind up creating a lot of value. Again, I think for most of the everyday contracts that consumers and even employees, for that matter, are engaging in, smart contracts will provide a mechanism for reducing the need for a lot of legal oversight. So in that sense, that's what I mean about the distribution. Lawyers who are making their living dealing with small clients and helping them, create contracts or standardize contracts, that sort of work is going to become slimmer and harder to find. And I think that will wind up creating value for small businesses. They're spending money on lawyers and legal fees that they may not need to spend anymore, or they may spend once. They might have someone help them with the if-then statements on the front end, but then they won't need a lot of updating, right? So there won't be needs to worry about legal changes or legal disputes or those sorts of things. So you might have a little bit of assistance up front, but probably not a lot after that.
Okay, I'm going to hand back to Steve. if you're going to
Yep.
ask if there's any questions.
If anybody else has any questions, if you want to raise your hand, I'm looking at the attendees list so I can identify who's got a question. Okay, Natalie's got a comment there. Seems
Yeah, I
great
was
for
just trying to
everyday
read.
relational contracts, but not for highly complex commercial contracts where terms need varying, modifying, etc. Yeah, thanks for that comment, Natalie, and that's actually very reassuring for me because my wife is a commercial lawyer. So I was absolutely terrified when you started your talk, Henry, to say that she might be out of work, but delighted to hear that your conclusion that she is still going to be contributing an income to the Hills Gomez family household. So that was very reassuring. Also delighted to hear that commercial law can be interesting because I also want my wife to be happy in her work. Ronka, you have a question.
Hi, thank you, Stephen. I'm laughing because my first comment was that I'm glad to hear that we're not completely in the realms of the dinosaur. So there's still some hope for us yet.
There's still hope.
Still hope.
Oh,
It's more of a comment actually because we've been thinking about how AI is likely to affect students' training. It's going to change the mechanisms in terms of how we teach them. Do we include IT training as part of the core modules that students need to learn? We've already been having discussions about raising commercial awareness for students. So for the law students, for example, having an understanding that the number of the nature of contracts, of property agreements and so on, hasn't really changed in the last 20 or 30 years, but the number of people that are qualifying as lawyers has increased tenfold. So how are we to fit in this dynamic? I can see that commercial law and contracts work well in terms of how AI can support the small contracts. I can imagine that there will still be a great demand for magic circle firms because in that context, people want personalized service. They want to see a person. They want to see that the law firms are taking on a degree of risk in terms of representing them. But I wonder whether or not AI might have a role to play, and maybe a question for you, whether AI has a role to play in other areas of law, family law, dispute resolution, or is that beyond the pale in terms of, we still have a need for seeing people and speaking to people?
no, I think it's a great question, Rocky, and thank you for the question, and thank you, Natalie, as well for the comment in the chat. Just a quick thing about Natalie's comment, which I think actually does bridge a little bit into what Ron was saying. I agree wholeheartedly that smart contracts will not replace those complex commercial contracts. In fact, there's a whole area of contracting. I'm not even sure smart contracts. I think that they can contribute small pieces, but in what I like to think of as contracts where we're thinking about contracts for innovation. I call them contracts for innovation in circumstances where we don't have a specific outcome that we're contracting for, but instead contracting for a process of development, like a pharmaceutical company working with a scientist or working with a subcontractor to try to develop a new treatment. We can't reach agreement on the outcome, but we can think about the process. In those circumstances, then absolutely we'll still have traditional contracting as the primary driver. Our contracts might be able to contribute little pieces. I also should say that when I think about the role of contracts, even complex commercial deals, I think not only will smart contract not eliminate the need for lawyers in those deals, I think it will not eliminate the need for traditional contracts in those deals. So traditional contracts are not going to go away anytime soon because of contracting. Your question, Rocky, is the idea of AI and even uses of blockchain likely to impact other areas of law? Absolutely. I think we already are beginning to see variety of places where AI is being used to change the work of lawyering pretty fundamentally. I mean, we certainly have seen that, as I mentioned at the beginning, thinking about things like predictive coding and going through document review. I mean, I remember when I first started practicing law, we would hire firms that would have, a couple hundred people, who were just temporary workers, often students or whatever, to review documents, and everybody, we'd have this gigantic room of people who would be looking at our millions of documents. Long gone are those days, and that's just within my lifetime of practice. That's all done now by predictive coding, and those firms that are engaging in predictive coding, I think, not only providing a service, but they've changed the way that lawyering works. And going to the question or the comment you made, Ronki, about teaching then our law students some basics of quantitative thinking and quantitative processing is really important. Lawyers have an ethical obligation to understand the nature of the client representation. As a dispute resolution professional, if you don't understand at least the basics of how predictive coding is working, and predictive coding be eliminating 900,000 documents that you or no one from your law firm ever looks at, right? Limiting down to 100,000 documents, that process is a question of lawyering ethics. If you don't understand that process, as we know, the file down to 100,000 documents, not only might you be making representational errors, but you're not abiding by your professional obligation to understand the nature of the representation, I think. But then I think outside of that, there are lots of other very exciting and changing ways that the law is going to be altered through AI. So dispute resolution, there's lots of talk right now, and there are lots of firms right now that use AI mediators, especially for lower stakes cases. So there's not a physical or person at all. It's basically a complex algorithm that helps parties reach mediated solutions. There are several companies that offer that right now, and I was actually a participant as a consultant before I joined London Met. The case that was a £2 million dispute, and parties used an AI mediator were able to reach a resolution. It was enlightening, to say the least, but that process is likely to start to influence other dispute resolution processes. There are some AI arbitration services that are at least assisting arbitrators in gathering documents, asking questions of things. Client intake is a place where we see more AI, and then in other domains of law besides commercial law. So, I mean, all of those areas we can use in any domain, but I think we can see this in courtroom processes across, a trans-substantive sort of courtroom process. We see more and more uses of AI to help decision makers make decisions, questions, intake forms, those sorts of things. So yeah, I think AI will change the nature of law dramatically. Blockchain will change the nature of law. Blockchain can be used for things beyond smart contracting, certainly anytime where we've got to have an exchange of something and we want it on certain terms and conditions. So I think that will be used creatively in a lot of domains.
Thank you. Thank you.
Any other questions, colleagues?
Advantages to lawyers, and Natalie was saying, if I read that correctly, advantages to lawyers in terms of accuracy and those sorts of things. I mean, conceivably, there is. That's one of the advantages of blockchain, at least theoretically, is that there's no worry about accuracy, right? The terms, those if-then statements that are creating the blockchain terms and conditions are immutable, and they either are satisfied or they're not, and the computer is analyzing those questions. Now, again, that assumes, in a way that many proponents of blockchain assume and sort of assume away in a black box, that the computer can verify those things, those conditions. In many instances, I think who are thinking of blockchain are thinking about these mass market transactions where the condition is pay money by a certain date, put money into escrow, put money into the escrow account by a certain date. That can be verified very easily by the computer. There's no need for external eyeballs to engage in the evaluation or the observation of whether that condition has been satisfied or not. More complex contracts there would be, and so I agree with you in that sense, Natalie. Once we have conditions that are no longer so simple, so routinized, then having lawyers involved might improve the caliber of the process by making it more accurate or more precise. Certainly the overhang of law theoretically should be making it more accurate and more precise. That's a good question. Would it work differently in a common law system versus a civil law system? I don't know that it necessarily would. I think that the dispute resolution part of, I don't think the smart contract itself would be particularly different. I think that if you take seriously my notion that what value lawyers are bringing to a transaction is always about dispute resolution processes. So as transactional designers, they're trying to minimize the risks of potential future dispute resolution. And then of course, as litigators on the back end of the contract, they're managing the dispute resolution process. In that sense, I think there are changes in the way that you design a contract and certainly in the way you litigate a contract, whether you're in a civil law or a common law country, but the actual blockchain and smart contract probably doesn't change dramatically.
Okay, I think we'll draw to a close now the questions. Thank you so much for being our inaugural presenter, Henry. That was a really interesting presentation, and thanks for going into such depth in answering those questions as well. So we're going to move on to the next item on the agenda, which is to look at the schedule of events. So let me just go ahead and pull that up now, and let me just zoom in a bit so that we can see that. So just to give you just a quick word on the kind of events that we're looking to run, we really want to have a nice mixture of events each year. So mixture in terms of internal members of the research center presenting, internal members of LMU, but not necessarily members of the research center also presenting, having external presenters coming in and presenting, so a mixture in that sense. But as well as presentations, we also want to make sure that we're having working meetings. So if we start to look down here, you can see some of the more working meetings that we're planning. So, and we're also incorporating here some of the PGR training sessions that members of the research center will be providing. So obviously here we've got today's session. The next one after this, the event after this is going to be one of the working meetings that I was referring to. So on Friday, the 22nd of April at 2 p.m, we're hoping to engage the PhD students and start to understand their development needs, and therefore thinking about how the research center can support PhD students in their development. Then on Tuesday, the 26th of April, we have our opening external presentation, non-LMU presenter, and this is going to be Professor Umit Batici from the Edinburgh Business School at Heriot-Watt University, who's going to be looking at performance and why it matters, which is obviously very topical with the title of the research center, Performance with Purpose. We've then got our first PGR training event, which is being delivered by the director of the research center, looking at giving a conference paper. And then we're going to have another working meeting on Friday, the 29th of April, where we've really got two focuses right now. So we're in line with Henry's presentation just now. We've got the focus on intermediaries, but we're also wanting to remain focused on smaller businesses. So we want to just really do somewhat of an audit around what we have done, what we're doing, and what do we know, including theory and methods with regard to research around smaller businesses. So a bit of an audit for that event at the end of this month. Then I'm going to be delivering a PGR training session on applied regression modeling using the example of social distancing adherence, but also just looking more at the basics of regression modeling. I'm sure there's some colleagues here would be more advanced in their regression modeling than I am with my SPSS modeling, and who actually would do it coding. So they'll come and scoff at my SPSS modeling there, no doubt. We've then got an internal presentation from Sarush. He's still reflecting upon what his topic is going to be, and we'll know that in the near future. And then we have another PGR training session on Tuesday, 17th of May, by Nigel again, now looking at publishing in peer-reviewed journals. And then we move on to another working meeting where we're doing a follow-up on the previous session on smaller businesses, starting to think about what we want to do moving forward. And then we've got a follow-up to the previous event with the PhD students, where now, having listened to what their development needs are, we're actually going to be starting to think about what we can do to meet their needs and to actually deliver a workshop in regard to that. Having gone through a very hectic April and May with the research centre, we're going to start to wind down as we get more into the summer. And so we just got a couple of events in June. So as well as the development of PhD students, we've got a session on planning for the Festival of Contemporary Research Methods, which is now going to fall under the remit of the research centre. So we're going to have that towards the end of June, and then in July we're returning to a wider project that's starting to take shape now, which is a catch up on the research centre projects regarding intermediaries and smaller businesses and consulting members. So this is some money that we secured from the I think it was the Rescaling Fund, and we've actually, as of today, we hired our third and final research assistant. So all 3 research assistants are now in place for this project, and we're looking at 3 different areas that are being led by one being led by Doris, one being led by Konstantinos, and one being led by Anil. So all 3 research assistants are in place. So we're ready to move forward with that broader project now. We're then going to give you a bit of time away from us, and before coming back in the middle of September, keeping the same week that we've had the last couple of years for the Festival of Contemporary Research Methods, which is the week before Welcome Week and 2 weeks before teaching starts. That event's going to run from Wednesday to Friday, much in the same kind of structure as it's run the previous 2 years. So that's what we've got running for the rest of this year. We've also got some things for next year that we haven't yet scheduled. We've got some. We're going to have some sessions around knowledge transfer partnerships, and we're going to be looking at some work that I'm doing with Fight for Change and an application that we're looking to complete over the summer break for some funding via a knowledge transfer partnership. There's also going to be a presentation from UNICEF, who are going to be talking to us about funded knowledge exchange between universities and major charities. We've got a Meet the Editor session planned, and we've also got an external presentation from Professor Jill Hopkinson at Lancaster University on intermediaries and franchises, and another external presentation that is either going to happen, we're either going to try and squeeze in this year, but probably more likely next year, is going to be from Claudio Giacetti, who is a co-author of our very own Konstantinos, who's going to be giving us a presentation. So that's what we're looking at this year, and also a preview of some of the things that's going to be happening next year. it looks a lot, and we wanted it to be quite hectic because we're trying to squeeze things into the end of the academic year, going forward, and when we've got a full year in the next academic year, we're going to space things out a little bit more, so it won't be quite as hectic. But we really wanted to kick things off and be active, and in particular lots of working meetings, so that we can take on information and see where we are with audits and development needs, so that we can be productive in the summer, in a good position to be very effective in the next academic year. So that's everything on the event schedule. So we're now going to move on to the final item on the agenda, which is to open it up to the floor and via a Q&A session. So you can ask either myself some questions, or you can ask our director, Nigel Caldwell, some questions. So over to the floor. Happy to take any questions that you've got. I'm going to stop the recording now, because we do want you to be able to speak freely. And we did decide before this meeting that we wouldn't record the Q&A session. So I'm going to end the recording now and open up the floor for Q&A.